Step away from the quickie. When a law enforcement officer or other agent of the state induces someone to commit a crime they otherwise would not have committed, that's called entrapment, and it means the person isn't legally culpable. So they have to be careful in undercover or sting operations. They may have to prove beyond a reasonable doubt that the defendant would still have committed the crime without their participation. It varies around the world, but it's generally close to one of two concepts, both of which are used in the United States. The first is the subjective test, which requires mens rea, where the defendant has a prior intent or at least predisposition to commit a crime. On the other hand, the objective test looks solely at the conduct of the government when their actions would have caused not the defendant specifically, but any normally law-abiding person to commit the crime. But neither of those were applied in the last major Supreme Court ruling on the subject, Jacobson v. United States. In 1985, Postal Service agents sent Keith Jacobson repeated letters from a fictitious free speech organization to try and get him to sign up to receive child abuse material. They made repeated attempts over the next 2 years to get him to respond. Giving in to his curiosity, Jacobson finally ordered the material, and he was arrested when he went to the post office to pick it up. The only question the Supreme Court said was relevant was whether or not the defendant had any predisposition for purchasing the material, which had only just been made illegal. They found it hadn't, and that the idea had been put into his mind by Postal Service officials. They overturned his conviction. One thing history has shown is that there is no trusting law enforcement or any other government official. The existence of entrapment is just one more fact establishing it.